Ms. Schwartz, welcome.
Yes, good afternoon and welcome to the new year. I'm going to reserve 2 minutes for rebuttal.
All right. Please proceed.
Subdivision 1 of Criminal Procedure Law 42040 provides that hardship deferral of surcharges are available to all defendants receiving mandatory surcharges at sentencing. Knowing this, it should be clear that the legislature did not intend to create two classes of cases.
Counsel, don't we have to look at 60-30 and 420? Don't we have to look at 60? Don't we have to look at 60.35 when we also look at 420-10 or 420-40?
Yes, and 6035, subdivision 8, the latter part of that subdivision, deals directly with non-summonses cases where the defendant is sentenced to more than 60 days.
Was your client sentenced to more than 60 days?
Yes, he was. He was sentenced to 6 months.
So don't we have to look at both statutes, not just
Yes.
the one?
Yes, and both statutes support a conclusion that the court has the power at sentencing to conduct hardship hearings for those cases that do not get a summons for 60 days later. In other words, cases where defendants are sentenced to more than 60 days.
So your position is that no summons has to be first served on a defendant before a court can hear a hardship?
Well, CPL 42040 subdivision 2 spells out a procedure for cases where the sentence is 60 days or less. And in those cases, it's required that the court simultaneously at sentencing issue a summons. During that 60-day period, it's sort of like a grace period.
Why is that? I saw that in your book. Why is that a grace period?
Well,
don't the statutes require that they start collecting if there is anything to be collected while someone's incarcerated? Why doesn't that apply to a client or a defendant who's less than 60 days?
Because Penal Law 6035 subdivision 5, which deals with the collection of incarcerated defendants, states that it is immediate collection for those defendants where payment is due. But in the cases where a summons is issued, those cases, the payment is not due.
No. 60.358 says that the summons is issued if after and applies, and they have to show up. If after 60 days from the date it was imposed, it remains unpaid. Doesn't that mean that the defendant could indeed pay, or that while they're incarcerated, money could be collected from their account?
It says where they have failed to pay the mandatory surcharge. In these cases, in cases where a summons is issued, they haven't failed to pay. They still have the right.
I'm sorry, what line are you
So in subdivision 5, it says when a person who is convicted of a crime or violation and sentenced to a term of imprisonment has failed to pay the mandatory.
No, I'm looking at 60.358 that deals with the summonses.
So in that case, where are you looking at, Your Honor?
At the time the mandatory surcharge is imposed, court shall issue and cause to be served upon the person required to pay the mandatory surcharge a summons directing that they appear before the court regarding the payment of the surcharge if after 60 days, obviously I'm not reading about the other types of fees, only the mandatory surcharge. If after 60 days from the date it was imposed, it remains unpaid.
Okay.
So they, of course, voluntarily could pay, but my question is, are you reading this to mean that they're also excluded from the other statutory provisions that require that if they have any money, it be taken from their inmate account?
Yes.
What you're calling that grace period?
Yes, and that's because of 6035 subdivision 5, which only authorizes the collection from inmate funds when the person has failed to pay the mandatory surcharge.
Well, it seemed, if you look at the legislative history of this whole thing, that the legislature is getting a little peeved at the courts for waiving these fees on a fairly regular basis. In fact, if you look at the legislative history, it was talking about how like 80% of the fees were being waived by courts, and they seemed to get pretty upset by that, and they therefore said we can't waive them. Courts can't waive them anymore. They can defer them only.
Correct.
Right.
But so this isn't a waiver But it is a deferral.
So what's the point of making an application for a deferral until after you get out? It would seem to me it would defeat the whole purpose of the statute to say, well, you can defer it during the 25 to life that you're doing on this case, and then we'll take it up in the event that you somehow get out.
Well, the deferral would only be granted if the individual can demonstrate by credible and verifiable information that collection of the surcharge would cause an unreasonable hardship to that individual or his or her immediate family.
Well, why would you talked about creating two separate classes, but under your interpretation, then the person that's going to be incarcerated for more than 60 days gets an immediate hearing, whether he or she has attempted to pay or not, whereas the person who's going to be incarcerated for less than 60 days gets this grace period. Why would that be?
Because the individual who is issued a summons doesn't need to make payment until the 60 days, and in the summons part, they have the right to a hardship deferral.
I'm still unclear how you read the statutes to say that because 60.358 allows the court to issue this summons that they're going to appear if they haven't paid means that they don't have to pay, number one, or number two, that they can't have their account credited, right? The money taken out of their prisoner account.
And that's because Penal Law 6035-5.
I know you've said that, but I don't see, I need you to explain that in 35.5. All it says is someone who hasn't paid. So I'm at sentencing, I don't pay, I now go to jail. What in the statute says that they can't collect from my inmate account if there's anything to collect? Granted, if there's nothing to collect, you can't collect anything.
Because the summons is the summons to pay, so they have the 60 days to come up with the payment.
Is to show up if you have not paid.
Or pay in full if they do. So if they pay in full, they're done, but it isn't due until 60 days later. It's treated as a 60-day grace period.
This is where I'm a little confused. You're saying that the summons is issued at sentencing, but the statute seems to say that the summons is issued if one has failed to pay after 60 days.
No. The statute, which is 6035 subdivision 8, says that at sentencing, if the sentence is 60 days or less, at that time they're required to issue a summons. The summons basically says you have 60 days to make payment in full, and then you don't have to come back to court. But if day 60 arrives and you still haven't made payment, you have to come into court and ask for the surcharge deferral hearing or make some partial payment and get an adjourned date. And that's how it's interpreted. But what happens with those individuals who are sentenced to more than 60 days, CPL 6035 subdivision 5 says that they are immediately due. And so that means when they go to the confining facility, the facility can immediately begin to take the funds out of their inmate accounts.
That's what I understood Judge Stein to be asking. You're saying that the lesser sentenced people don't have to pay. They have this grace period of some sort. When in fact I think they do have to pay, and if they don't pay it, then the summons is going to be issued after 60. Is it your experience that when someone is sentenced to a period of incarceration of 60 days or less, that at that time somebody, I don't know who it would be, but somebody then says, by the way, as you're on your way to jail, here's a summons for the amount of the surcharge? It happens at the sentence?
At sentencing, that's what the statute requires.
I'm asking you your experience. In other words, if you're in court, I would be surprised if I'm standing with my client and he just gets, let's say, 45 days on a DWI and someone said, and by the way, here's a summons for the surcharge.
Yeah.
I'd be wondering who's the lawyer that's now suing my client for that, and what do I have to do to properly represent my client at that time?
I can't say how the paperwork is distributed, but I do know that that's what the statute indicates. And so what happens is those people sentenced to 60 days or less are given additional paperwork and said, you must make payment of your mandatory surcharges in the summons part 60 days later. So anyone who's sentenced to...
Aren't we stuck, if there's a legislative logic for the 60-day distinction for minor crimes as opposed to anything more than 60 days. I would say anything above a B misdemeanor, but that may not be the case. But anyway, anything beyond 60 days, if there's a legislative logic to what they're doing, then aren't we stuck? We don't really have any discretion here to go beyond that.
Well, the statutes give authority for entertaining deferral hearings at sentencing for those individuals who are sentenced to more than 60 days, and that's through the Penal Law 60.30. It gives full civil authority to the sentencing court. So what's really happened...
Pardon me, but that seemed to read that they could impose more of a civil penalty, not that they could forgive one.
Well,
I don't know if I agree with that reading of it.
Well, the provision does say that they have the power to impose appropriate orders as a part of the judgment of conviction.
All right. That isn't the same as deferring a mandatory fee. Those are a little bit. That's something a little bit different. So assume that that's the case. We disagree with you about that. Then, what's the only other way that this court could address this issue? It seems to me that we'd have to look to the intent of the legislature and say there's no logical basis for this 60-day distinction.
Well, I think that the intent of the legislature was to make sure that the mandatory nature of the surcharges was
right. They were
honored.
trying to cut out
so those individuals...
Slow down. They were trying to cut out all the wiggle room for the courts. I understand that. But my question, I guess, to you is, can you point to something in the legislative history that you think would allow us to draw that distinction?
Well, I think that the absence of any express language creating the distinction or explaining why 60 days was the magic number where you have the right to hardship deferral or where you don't, it's utterly silent. I believe the reason they created the summons part was to make those individuals who are sentenced to 60 days or less to really have to struggle and come up with the money. And if they can't at 60 days, then they have to go back to court and make that application. So that might encourage people to comply. Whereas
why wouldn't they make that same requirement of somebody that's going to prison for a longer time?
Well, the problem, the best, an illustration here explains it. Someone who's sentenced to 60 days versus someone who's sentenced to 61 days. The person who's sentenced to 60 days doesn't have to pay the surcharge and then goes to court at the summons part and asks for his hardship deferral.
Isn't it a civil judgment against them? Doesn't it stand as a civil judgment when they don't pay that day at sentencing? I guess I'm not understanding 60-day grace period, but I'll ask the people about that.
The statutes do authorize imprisonment for failure to pay the surcharges. So that's why there's a distinction between entering judgment, which is what would happen if the court found that there was substantial hardship and granted deferral. So there's
Ms. Bautista is chomping at the bit to say something, so why don't we excuse you and ask her to...
Thank you.
Thank you. Good afternoon, Ms. Bautista.
Good afternoon, Judge Piggott. Good afternoon, Your Honors. May it please the Court, my name is Sheila Bautista, and I represent the people in this case. Your Honors, the legislature's priority with respect to the mandatory surcharge is its imposition and collection. The statutes clearly state that it is to be imposed at sentencing, then collected from the defendant's inmate account, regardless of the length of his sentence.
So there's no grace period?
There's no grace period. The plain language of 6035, subsection 5, directs that the superintendent of the facility or the municipal official collect the money from the inmate's account, which contemplates, by designating a superintendent or a municipal official, that contemplates jail terms or state prison terms. So it's the people's position that there is no grace period. 6035.5 says...
Is your experience, though, counsel, that the summons is issued at sentencing for those who are sentenced to 60 days or less?
Your Honor, I don't have experience in the trial courts. However, our reading of the statute is that 6035 subsection 8, which talks about the summons, our reading is that it should be issued at sentencing if the defendant hasn't paid.
That's the troubling part. It was described, I guess, in the notes as poorly drafted and difficult to follow, I think. Yes, difficult to follow. That's the way.
Well, it's clear from this.
Well, and what I wanted to say then is that we have a poorly drafted, difficult to follow statute, and no one seems to have any experience with exactly what happens here, particularly with respect to the 60 days or less. Because 60 days and beyond, I don't think Ms. Schwartz refers to 61 days, but I picture the person that gets 3.5 to 7 or 25 to life. I mean, I doubt that they care too much about what the surcharge is, except that it's coming out of their monthly thing. But on the 60 and less, I just have no feel for that, and you don't either, on how the summons part is supposed to work.
Your Honor, the statute states that the summons is to be issued.
No, I'm aware of that, but I'm curious as to how that happens. I'm trying to picture the defendant standing there and saying, by the way, on your way to jail, here's a summons. You've got 20 days to answer, or you've got 60 days to answer, or the plaintiff is so-and-so, and by the way, criminal defense lawyer, you're now a civil defense lawyer. You have to defend him on the civil action that's being brought against him for the surcharge. I'm just curious as to how it operates.
Unfortunately, Your Honor, I don't have that in this record because this defendant was sentenced to greater than 60 days. And our position is that here.
Well, perhaps you can bring some clarity to what the summons, as the statute is supposed to say. How is it supposed to work?
A summons should be issued, and it tells the defendant that if you have not paid within 60 days, you must appear on this date 60 days after the imposition.
And if you have paid, you provide some kind of proof so that you don't have to show up, or you could show up with the proof.
That's my understanding. That's if it's unpaid. If it's paid,
enforcement mechanism. It's not a you get 60 days. It's you better pay, but if you haven't in 60 days, you better show up in court and make an argument why it should be deferred.
Correct. Correct.
I thought in Buffalo the court clerk sends them out. I was actually on city court before the old days, and Judge Pickett is right. We did try to defer or waive every fee that we could. Usually when you're giving someone some serious time, it seemed like the height of cruelty to add a financial penalty to people that couldn't pay it at the end of giving them the time. So it's true. We would try to waive them all the time. I think that 80% is probably low. It's probably near 90% they could get away with it. But so these laws were passed actually while I was in city court, and they were passed to do exactly what you argue, which is to make sure that there was no more wiggle room for the courts to be able to do this. But the way the process works, at least it did then when I was still there, is that the court clerk would send out a summons subsequent to the sentencing for the 68 people, and they would get a notice, either pay it or appear at such and such date. And then they just roll them forward. They just rolled forward all the time. So.
But this
pretty straightforward.
And it just all goes to show, though, that the deferral is not available at sentencing, which is the issue in this case. With all due respect, the practice of the judges, the legislature made clear they didn't want the judges to exercise that judicial discretion. And
you concede that this could result in, somebody applying post-sentencing and then having to bring them back into court and, all that additional bureaucracy or whatever you want to call it.
Well, Your Honor, there are three main reasons why deferral at sentencing shouldn't be made available. As a practical matter, a defendant wouldn't be able to show at sentencing that he suffers an undue hardship from the mandatory surcharge because he has not yet begun his incarceratory sentence.
Well, pick up on one of the things that Judge Fay is saying. If you got assigned counsel or the public defender representing you in city court or somewhere else, and because you do not have sufficient funds to hire a lawyer, it's a pretty good indication that you're probably going to have trouble paying this mandatory surcharge. I would think that would be the application it would be.
But, Your Honor, also making it available at sentencing, making the deferral available at sentencing would preclude the docs from collecting it from the defendant, which would conflict with the mandate that it be collected from him while he is incarcerated.
But docs is only a year or more. If you got 60 days, you're going to be doing local time. And that won't be docs. That will be, I guess, as Judge Fay is indicating, somehow the city court does it.
And if deferral will be available at sentencing for this defendant, then the city authorities would not be collecting from his inmate count as 6035 mandates. It would conflict with that mandate, and it would, as a practical matter, the deferral would amount to the waiver that the legislature tried so hard to curb by making the mandatory surcharge mandatory and waivers totally unavailable. Because if deferral were available at sentencing, either city or docs would not collect anymore.
But
that would amount to a
waiver. The process has been created. Let me ask a question in honor of Judge Lippman. Does this seem fair? Because what the process has created, just from a fairness point of view, and this is the people, of course, are concerned about this too. Does it seem fair that you've created a process which has eliminated waivers, but by law has to have a deferral? We all agree that there's no way you can escape some form of a deferral in this by constitutional law. So if a deferral is required, you've created a deferral process which in essence is impossible to apply for once you've started to become incarcerated and you don't have counsel assigned to you anymore and you're already post-sentence. You see what I'm saying?
Yes,
Yeah.
yes, Your Honor, it does seem fair, because while the person is incarcerated, he has opportunities to earn money to pay the mandatory surcharge. He can participate in incentive programs, rehabilitation. These are incentives for him to take classes or work or
But my
things.
point is not that. My point, I agree with you. The collection process it is what it is. It's certainly, there's nothing unfair about that. The question is whether or not the virtual elimination of deferral is fair. And that's what this seems to do. This process seems to virtually eliminate deferral for anyone who's sentenced to any crime more than a B misdemeanor.
Yes, because the legislature saw fit to make this surcharge mandatory. And that's what the legislature said, and it's clear from their statute that this is a mandatory surcharge that can never be waived, and the defendant...
Well, could the legislature have actually written into the statute and it cannot be deferred?
There is a deferral process.
I
There is a deferral
understand. That
process.
wasn't my question.
Right.
Could the legislature have chosen to even remove the opportunity for deferral?
They
for
could
deferment?
have, but they didn't, because it is still available, but it's clearly not available at sentencing, because the only deferral process that they describe is not available to people, for the people who are sentenced to less than 60 days. It's not available until they're out, until they've served their time. So there is a deferral process, it's just not available at sentencing, because it conflicts
The
with...
summons, I'm still curious about the summons, counsel. For someone who's sentenced to more than 60 days, is the summons issued at sentencing, or is it only issued after the person has, or, well, it won't be issued for someone who's 60 days, whose sentence is more than 60 days because they'll be incarcerated, and the statute won't allow them to be summoned while they're incarcerated, correct?
Correct. My understanding is that the summons is not issued to the defendants who are sentenced to greater than 60 days. But our position is that for persons sentenced later, they still have a deferral mechanism under 42010 subsection 5.
But that mechanism requires them to bring a motion to be resentenced.
Correct.
And when they move to be resentenced, what are the mechanisms available for deferral for them?
The resentencing motion,
Yes.
they would have to make a showing of undue hardship, similar to what the defendant's sentence less than 60 days show. They'd have to make that showing. Upon that showing, the court could decide whether or not to defer the judgment. It would become a civil judgment.
So it's just a matter of when they can make this request to be considered for deferral.
Correct.
Not
And-
whether they can ask for a deferral.
Correct. Our position is that deferral is available to all defendants, just not at sentencing.
Where's that standard you just set out for those who are incarcerated over 60 days?
Section 42035 says that the provisions of 42010 are applicable to the mandatory surcharge. And there is, 42010 subsection 5 has a resentencing provision. So since 6035 subsection 8 doesn't make it available to the defendant sentenced to greater than 60 days, we look to 42010 for those defendants.
And you're saying 42010 uses the language of unreasonable hardship that you find in 420.42? That applies to those under 60 days
It
incarcerated?
uses a similar language. It also says that incarceration alone is not a showing
Yes,
of
I know that.
unreasonable hardship. So if you look at 42010 subsection 5 and subsection 6, functionally, those are the equivalent of a 42040 subsection 5 deferral hearing that's available to the defendants who are sentenced to less than 60 days. So in a nutshell, that's our position. Our position is that deferral is available, just not at sentencing, because if so, it would conflict with the mandate to collect, and it would contravene the legislature's intent to curb judicial discretion to grant relief
Can
from
I
the
ask you what
mandatory
happened?
surcharge.
Let me just ask you. I've been given the 3.5 to 7. I think that's what Judge Piggott mentioned before. And I don't have a penny to my name. So I'm going in, and obviously Docs is now going to collect from my fund whenever any money goes into that fund. Is there a civil judgment that's been imposed?
Has it been deferred?
At sentencing or
Has it-
whenever, shortly thereafter? Is it now a civil judgment that I'm paying off? What am I paying off?
You're paying the mandatory surcharge.
So it's not a civil judgment, as in a
No.
lien under the CPLR? Because
No.
there are provisions
No,
for
it is-
making these things civil judgments.
Correct. It's a mandatory surcharge, and it does not become a civil judgment until the sentencing court notifies the clerk of court.
So since DOCS is collecting whatever amount it may be collecting, even 25 cents a month,
It's
it
20%.
will not be, whatever amount it, well, depending on the amount that I've got, it will not be converted to that civil judgment.
Not while they're incarcerated, but at the end of a person's incarceration, DOCS tells the sentencing court whether or not the defendant has paid the mandatory surcharge. Let me see if I can find that. I believe it's a directive. It's a DOCS directive. DOCS Directive 2788 at pages 8 to 9. DOCS tells the sentencing court whether or not the surcharge has been paid. And in turn, the sentencing court tells the state whether the mandatory surcharge has been paid or not. My understanding is the sentencing court can enter a civil judgment if a mandatory surcharge has been paid under CPL 42010 subsection 6. But it doesn't become a civil judgment until he gets out, is my
So
understanding.
release.
Right.
Thank you, Ms. Batista.
Thank you.
Ms. Schwartz, come on and straighten this out.
There's been a lot of questions about how the summons would work when someone is serving a shorter than 60-day sentence. And I've seen that happen in criminal court. I can tell you they are told about what to do. There's paperwork processed by the clerk, but it's not delivered to the defendant until they're released. At least that's how it happens in Manhattan.
Well, that would be
criminal
only
court.
for over 60 days. Yeah, other than that, you just mail it to them and they appear.
But, and the very similar procedures used in the compliance parts where defendants have to go to a drug treatment program or whatever they're told, they must return to court with compliance paperwork and to pay their
The bottom line, I
surcharges.
think, as Ms. Batista was pointing out, is that the legislature seems to have done everything in their power to make sure that we do not do anything but make sure these things get collected.
I have to respectfully disagree because, yes, they said no waiver, but we're saying it's imposed. It's just that it's deferred. And certainly the legislature has said the opposite because they created CPL 42040, and the whole point of that is deferral. So they've said
Someone
it's
is doing 3 to 7, and it's deferred while they're in prison. Does that mean that the state or the city has to wait for 7 years if they're going to do the full time before the mandatory surcharge can be collected, even though the inmate could be earning whatever amount? I know it's not a lot, but earning something in prison.
Well, before deferral would be granted, the court would have to be convinced that this individual was under such terrible, serious financial hardship that that imposition of the surcharge would cause an unreasonable hardship to him or his family, and that is a very difficult burden for him to make.
Isn't the legislation somewhat of a presumption that if you're going to prison for more than 60 days, as I believe the ADA just mentioned, you will have the ability to earn something while you're in prison, so the hardship won't be as hard or as difficult as someone who will get out 60 days or less?
Not every individual is eligible for work. There are people with medical conditions. There are people with serious financial obligations, court-ordered or otherwise, who aren't able to make those payments. So I think
So
what
then
the
nothing's
legislature...
collected against them, and there's no civil judgment against them. Isn't what the legislature, it appears from these statutes, is saying is, if you're in jail and you're collecting money, or money is put into your account, as I read the statutes also, if you've received money from someone and it goes into your account, that's fair game. They can collect off that, too, to pay the surcharge. Okay, so if you've got funds, we've got victims who, and victim services we're trying to fund as the state, we're going to collect while you're in jail. Isn't that what these statutes are saying? Regardless of whether or not anyone in this courtroom might have made that choice, that appears to be the legislative choice, is it not?
Yes, however, this legislature provided for deferral in the unusual circumstance where someone's small pittance of money they earn while in prison isn't even going to be enough for them to buy a toothbrush. And those people should be able to have equal access, for fairness purposes, to request deferral. Now, the 3.5 to 7 person's going to have a hardship.
They can, they just can't do it at sentencing.
But if they don't do it the only way to have a level playing field is for them to have it at sentencing, because at sentencing, as soon as they're sentenced, the courts can start withdrawing funds. So they're going to have funds withdrawn while
Our concern is you don't
depending-
want someone who's incarcerated to have their inmate account drained. I get your
Especially
argument,
these
but
extremely
yes, I get your
indigent.
argument. The question is whether or not you can read the statutes that way. And it seems pretty clear the statute is saying you collect from the minute they walk in to be incarcerated.
I would just
That
urge
we can
the court
start
to-
the collection process.
It's when they fail to pay, and a defendant who's issued a summons hasn't failed to pay until it's time to return for the summons. They are given a grace period that's 60 days in order to make payment one way or the other, and it's not until 60 days later that they fail to pay, whereas those people sentenced to more than 60 days, it's due immediately. So that's the distinction, and in order for the statute to be applied fairly to all individuals, the only way that...
Would it be fairly applied if we said that everybody is subject to have immediate collection upon incarceration? If we disagreed with you on this grace period, is that then a fair application? Again, it may be harsh, you may disagree with it, but it may be the legislative choice.
I don't think you could read 6035 sub 5 as saying that.
We'll take a look at it. I think your time has expired, but I appreciate your time. Thank you.